I always said the first and most important judgment that a judge should write or at least think about it is the fact, and it is much against the present day law, is a fact that he should think himself dispassionately whether he is fit to sit there or not.
So this is making the youngsters join firms, which in turn means that the firms will can't have a traditional model of practice. The firms will have to then have a business model of practice, adoptive. Then that becomes contrary to the nobility of this profession. So how do we come out of this cycle, sir?
So when you want litigation as your goal, first 5 years, 3 years, 10 years, you must forget about your sustenance. Whatever you get it. Without naming the persons, I'll tell you, in one of the major cases here in the High Court on a tender matter, I was engaged and a young lawyer who did a lot of research assisted me.
So just as a going from this, is there any the present selection process that is there, sir, now whatever that we have, you think it is bringing out the best of persons as judges, or you feel that we could have some change in that? Or also do you feel that it is because of familiarity, because it is done in a closed door method, because of familiarity of the judges who are in the power of either selecting or searching, recommending, that familiarity actually consciously or unconsciously may favor only people whom they know, are they familiar with, and may leave out better gems.
Yes.
So do you feel, sir, that is happening, or it has happened?
It has happened several times. It continues to happen as well.
So what's the way forward, sir? How to change? And
see, it is too late to change this collegium system.
I see. Okay.
Recommendation by the top judges. 3 here and 5 in Supreme Court, like that. But instead of a closed door session, they must select randomly a few senior lawyers.
Okay.
And the Advocate General.
Okay.
Invite them and ask them to suggest some names. Because they are in touch with all the lawyers every day. Day in and out, we meet them. So if they ask us, we can tell you, here is a very good judge material you can think of recommending. I am sorry to say that these recommendations go on a different level altogether.
Okay.
There is an element of communal...
Too much of communal lobbying.
Lot of
lobbying.
Then trying to, push somebody.
Yeah.
And I have seen, I don't want to name them, several of them who are not fit enough to be judges. I always said the first and most important judgment that a judge should write or at least think about it is the fact, and it is much against the present day law, is a fact that he should think himself dispassionately whether he is fit to sit there or not. Though he can't be a judge in his own causes every day what we plead and argue. But in this first judgment of his, he must be a judge in his own cause. He must decide, realize whether he is fit to go and do
a conscious retrospection whether he
is required.
So the ambition sometimes overtake your assessment. Then how do we do that? And that's what happens. Your ambitions, maybe the ambition of someone who is sitting there already, to see that you come up, so that I have someone who is, don't cut the line, and it goes on from one after another and after another.
It happens, you see, this ambition.
So you feel that this conscience is still there in our profession, both among judges and among advocates?
To some extent, yes.
We still have, and we can still call proudly our profession as a profession, sir? Or you think it has become more of a business? What is your thoughts on that?
See, if you look at the older generation of the lawyers who are still practicing, perhaps like me, we have a lot of respect for tradition. We have a lot of respect for the eligibility of a person either to be invited as a senior counsel. I have a lot of things to say about this
Yes, sir, please, why
selection
not?
of senior counsel.
Also.
Oh, it's terrible, I tell you. Supreme Court has blessed it, but I am sorry to say that's not the proper way of doing it.
Okay.
And even selection of judges.
Also.
If I can give you an example, I was invited by the Chief Justice, rather called, and said, please accept, I want to recommend your name.
Yes, sir. Yes, we know about that.
You know about it, and the recommendation went up. I gave my consent. Due to certain personal reasons,
You had
I had to withdraw.
Yeah.
And the Chief Justice and senior most judges were unhappy that I am withdrawing. I told them only one thing. You see, if I have certain personal problems, if I sit there on that chair, part of my mind is occupied by that. But if I sit on the chair, 100% I must devote to the cause for which I am sitting there. Very, very conscious decision I took to withdraw.
So it's a classic case where your conscious, your ambition was overcome by your conscious.
Yes.
So,
But there are still like that. But
there are still, sir, in profession, you think our profession
There are
is still as noble as we have heard it
this
to be? you
quality,
think?
yes. I would rather unhesitatingly quote Sri B.V. Acharya. He was also invited to accept. But for some reason he said no. Perhaps my very, very good friend Sri Udayavalla also said no.
And today they are the best of advocates that we have.
Top lawyers.
Yeah, so you really...
But the basic point, the underlining point is the fact that they are doing service to the profession in the profession. In whichever capacity you are, that is important. That is how things happen. But today there is a sorry state of affairs.
You feel, sir?
Yes.
Is there
collegium system of lobbying, closed door, I simply do not like it. There must be a consultation or a consultative process of a seniors. You can pick and choose. Bar Council chairman, Advocate General, some 2-3 senior lawyers by rotation. Say, look, we want to recommend the name of so-and-so, so-and-so. What is your opinion? See, that will bring the best out of it.
So it's a collective decision is what? Collective decision for a given...
apart from closed door conversations.
Other than closed door. So now, that is one aspect we spoke about the judges. Of course, it's always said that whenever advocates meet, they're always talking of judges. And when judges meet, they're always talking of advocates. But I think it's let us, so long as it's healthy and it is for the promotion of our judiciary as a whole, then conversations should happen.
Should happen. Yes.
So now, insofar as advocates are concerned, sir, the profession, the noble profession that we say that we're not allowed to advertise ourselves, our rules are there. So in the changing world that is happening, no doubt a advocate's profession, I believe, is a one-man show. And that is how it has been, and predominantly all over the country you can see this one-man show is what really takes over at the end. Maybe there could be a team of people who will help this given advocate, but in the end he or she is what is going to be standing there to present the matter, and it ultimately depends on their conscience, their education and that knowledge that they have over there. But in the new age, with the Gen Z that we have, generation that we have, we are looking at people are more preferring firms than to individual advocates. So you think the firm, once you bring then the firms and then you have a advocates group, that means that you have to promote yourself, then it becomes a contrary to what rules that we have in our bar council. So what do you see, sir? What's the best?
See, this culture of clients running after firms to handle their cases was not there earlier.
Was not there earlier, okay.
It is a kind of a Western culture
Okay.
that has percolated into our system. You see, an young lawyer, after he graduates, enrolls, depending on his situation, you see, if he aspires to start earning money from day one, he would prefer to go and join some law firm where his income is secure.
Okay.
If he joins the office of a senior, you will never know. It all depends on how much the senior pays. For your sustenance at least.
Correct.
See,
Yeah, and I
this-
believe that's very, barring few exceptions that you have seen that I was at your chambers, so about me and maybe presently my office and few of others who
Yes.
pay considerably okay to the juniors. Juniors are not so much paid well. In fact, recently CJ also made a comment that young juniors. So this is making the youngsters join firms,
Run after
which in turn means that the firms will can't have a traditional model of practice. The firms will have to then have a business model of practice, adoptive. Then that becomes contrary to the nobility of this profession. So how do we come out of this cycle, sir?
See, in the beginning, of course, when the junior wants to, he should decide when he joins the profession whether he wants to join a corporate law firm and become a corporate lawyer. Most of the firms, they do have a branch of litigation kind of a lawyers, but very few. And if he wants really litigation as his main profession, he should think of, in my opinion, not the top senior lawyer, mid-level senior lawyer.
Okay, so that there's a scope to grow.
Scope to grow. A top lawyer, a senior lawyer, will only
not-
make use of
The
your, yes.
expertise and may not really
Yes.
guide you or may not have the time also to
Yeah,
do
he
so.
uses his expertise. He doesn't even encourage you by saying that. But I would firmly appeal, maybe I have also missed that. I tried my best to do at times. To all the senior lawyers, if they are properly assisted, well assisted by youngsters, at least at the end of their submissions, they must say, I'm grateful to my youngsters, young juniors who have assisted me there.
When they present.
They did
their
a
cases.
research on this topic. They helped me. I'm grateful. Some kind of an encouragement, you know. And some of the judges, they write in the judgments, which has become a rarity, saying that Mr. So-and-so senior counsel appeared, ably assisted by his juniors. That will give them some kind of an encouragement. So when you want litigation as your goal, first 5 years, 3 years, 10 years, you must forget about your sustenance. Whatever you get it. That's
So
all.
it's more of a learning.
More of a learning process.
And a very, there is no time frame for a legal profession. In fact, you shine only after
Few years.
and almost like
Depending
two,
on
two
your
decades or maybe
ability,
if you're on your
etc.
ability.
Yes, that is true. But today's seniors, I think quite a few are paying their juniors at least some sustenance allowances, you know, where they can sustain. A man comes from a district level. He stays in a hostel or he stays in a room. He eats outside in hotels. He needs some money. You see, he can't. He has an aspiration to become a lawyer in the High Court, or in place like Bangalore, both High Court and courts of first instance. We are not supposed to call them lower courts.
Lower courts, yes.
Courts of first instance.
Yes.
So, if he has to sustain, what should he do? He must be given. Give them some credit. Apart from that, some money. See, after 5-10 years, compare an young lawyer putting in 10 years of practice on the litigation side, coming out of a senior's lawyer and starting his own. He would have developed very well to start. Maybe a stage where he would take 1 or 2 juniors as well. Imagine his contemporary who is in a corporate law firm, except a few others get stagnated.
Okay.
That's my view. promotions are very limited.
Yeah, so
And,
you're essentially saying spend good time with seniors and then branch out on your own at a given point of time. And it's the duty of the senior at that point of time to assist us or assist the juniors or care them for some period of time, and that is how this...
without naming the persons, I'll tell you, in one of the major cases here in the High Court on a tender matter, I was engaged and a young lawyer who did a lot of research assisted me. He came to my office. He gave me a lot of judgments on the point.
Material.
And then facts, everything. He made synopsis. Though, of course, I believe in doing it on my own, as you know it.
Yes.
So I used that also. And then after the matter, we lost here. Of course, Supreme Court reversed that within a month's time. Then I was told by other colleagues that he has just started his office.
Okay.
He had engaged me.
Yes.
So he would get the fees from, the client for whom I was representing. Then I gave him substantial sum of money. Called him to my office and gave him. He said, "Why are you giving me, sir? I have never seen such a thing." I said, "I am told you are starting a new office. Buy something for yourself. Buy an iPad, buy a Mac or whatever it is.
Yes.
So that there's a lot of scope, digital world.
Yeah, any gadget that you need for office.
Yes. So start or contribute towards some journals and buy them. But first of all, have a full set of all the bare acts and be cautious of the amendments." This is how I told him, and I encouraged, gave him substantial sum of money from the fees I have received.
They must have been very happy.
Yeah, he was very happy. He was in tears. Next day, the other friends, including one of the additional advocate generals, came and told me that youngster was so happy. He was telling all his friends of what you did. I said, "Dear, we have to encourage
youngsters.
We were like that sometime back. We should not forget it."
So is it possible, sir, that we can bring in this practice of solicitors and barristers separately, like how it is in England, so that the solicitors office people who want to be in the legal profession yet to have a business model will be in the solicitor firm, and only those who are actually presenting before the court and who wants to have the traditional practice will be in the court? You feel such a kind of a bifurcation or something?
I am personally against such a thing.
Okay.
The reason being, a solicitor firm, when it starts, it invests a lot of money, as you said, as a business proposition.
So it has to have a business model, otherwise, because it has to get that many clients
to
sustain itself.
And to, if I can use the word, feed a lot of juniors in that firm. And they engage, because the clientele today have the habit of running after firms, not individuals.
Okay.
Lawyers, at least in majority cases. So you should be able to engage the top seniors. What happens? The solicitor firm grows, the seniors get more and more engagement. What happens to a young lawyer who has started on his own? There were so many of them. Such a practice you find only in metro cities. You don't find them in district levels or in rural areas. And if they come here, what happens to them if they want to set up their practice? Unless they are in close touch with a law firm or solicitors or whatever you call that, they will not be engaged in any matter to handle. If the clients, majority of them, top clients, big companies, international companies, look for the name of a firm, they never come to an individual. I have never seen, at least in international firms, if they have litigations in India, engaging a single senior or a mid-level lawyer who is not designated to handle their cases.
Yes.
They run after firms. What should happen
and
to
designated
them?
lawyers?
We are still not prepared in this country
for
to have
that
this kind of a situation.
Oh, okay.
Yes, we have to slowly develop. But this profession should not be only for the rich and haves. It should also be for have-nots.
Have-nots.
Who have talent. That is where I advise all my friends to read Die Empty.
Okay.
Die Empty.
Die empty, yes.
That's all.
As in empty in pockets or...
Die empty in your mind.
Oh, die empty in the mind, okay.
What happened was, how he wrote that book was, he was attending a conference.
Okay.
One of the questions which arose for consideration, just off the main topic in the conference, was, which is the richest land in this world? Somebody said Times Square in New York.
Yeah.
Extremely expensive land.
Most expensive land.
South African diamond mines.
Or somewhere in Japan.
Oil, Gulf, Japan. Everybody said. One person stood up and said, it's the graveyard.
Oh, I see.
Cemetery. Why do you say that? They said, you see a lot of thoughts, ideas, half written, which were not completed. They all get buried and died here. So this is the richest land in the world.
Okay.
So the author wrote the book, Henry Ford, I think, Die Empty. So before you breathe your last, don't keep anything in your mind and go to the burial ground. Give it away to others.
Give everything, whatever knowledge.
Yes.
Whether it is a wealth of knowledge or just give it to people.
Share.
And I think in our profession, wealth of knowledge is what is
more important
to be passed on from generation to generation.
Other kind of a wealth, you see, also is required. But there
it has
are
its own limitations.
Lot of sharers and aspirants.
Yes.
Unlike the sharing of wealth of knowledge.
So of course,
I would advise you to read that book. I'll gift you one book. I'll get it in 10 days' time and give you.
Yeah, thank you, sir.
It's a lovely book.